Sierra Crest Homeowners Association versus L. Frederick Francis, Ginger Francis, Anthony Castarenas, Jesus Carrillo, Joshua Ladd, John Gates, Lillian Crouch, and John Scott. We have Mr. Kevin Terrazas here on behalf of the petitioner. Here today, we're going to consider their request for a temporary injunction. So, Mr. Terrazas, you may proceed.
We've got a pretty short presentation for you, and thank you for your time today. We are seeking a temporary restraining order. We are seeking a 14-day hiatus involving a proceeding that is going to happen actually tomorrow, involving replatting of several parcels of land that we believe were improperly sold to the Francises. To be clear here, the last peaceable moment in this case was prior to the purchase of these parcels. Currently, the land is as it was before in terms of separated into parcels, and there is a dispute over the ownership of those parcels. My client has filed a lis pendens on those parcels because it believes that it is the rightful owner of those. I'm going to go and take the court to the CCRs. These were attached to our petition. They were verified by in our petition, along with all the facts that are contained therein. And so the bulk of what I'm going to be presenting is already in the petition itself that's been verified. We have witnesses here if the court would like to verify any of the others, and I'm going to go through a number of different exhibits that we can also provide to the court.
Judge, if I may, I do have an objection. I know this is somewhat opening, but this is also inform Mr. Terrazas that we do intend to object to the introduction of any verified pleadings, petitions, any affidavits as substantive proof of the request for the temporary restraining order, Judge.
On what basis are you objecting?
Judge, we do have the right to object to that under the Texas Rules of Civil Procedure, that verified pleadings are not by themselves proof, neither are affidavits. I point the court to the Texas Supreme Court in Millwright's Local Union versus Rust Engineering, 433 Southwest 2nd, 683. The court held there that absent agreement of the parties, the proof of required to support a temporary injunction may not be made by affidavit, and a sworn petition is not evidence, Judge.
Right. That was a temporary injunction hearing?
And I believe it applies under this as well, Your Honor. I have a myriad of cases that apply under the same principle.
Can you tell me one that relies on that principle for a temporary restraining order case?
Well, Judge, we could begin with Texas Rule of Civil Procedure 680 that speaks to that.
Well, does it say it's for in a temporary restraining order manner?
Yes,
okay.
Well, so, Your Honor, I apologize for interrupting here, but just to be clear, I'm just going to read Texas Rule of Civil Procedure 680. No temporary restraining order shall be granted without notice to the adverse party unless it clearly appears from specific facts shown by affidavit or by the verified complaint that immediate and irreparable injury, loss, or damage will result to the applicant before notice can be served and the hearing had thereon. Your Honor, that it specifically provides in the rule for a temporary restraining order that affidavits are sufficient. Again, you can do it ex parte. And so there's no requirement for any live testimony whatsoever. We do have witnesses that can testify this as well. But I also don't think, for example, these are the CCRs. It's our public document. I don't know of any objection to these in terms of authenticity, hearsay, anything like that, because it is not hearsay, or it's an exception to hearsay under the rules, and it's a publicly filed document that's been controlling this homeowner association for over 10 years.
Now, I'm going to overrule the...
Judge, just to be clear, so it's for the record, just to be clear, Judge, we object to the admission of any affidavits or verified pleadings as applications as proof. Absent an agreement of the parties, which we don't have, affidavits are not competent evidence to support a temporary injunction. Again, I refer the court back to Millwrights. I have a Another citation for Yona versus King, 15 Southwest 2nd, 653, Leston v. Barnes, 979, Southwest 2nd, 414, and a number of others, Judge. We asked the court to exclude these affidavits and verified petition and require competent actual evidence before the court rules on this temporary restraining order.
Thank you. I appreciate that. For the record, your objections are overruled. Mr. Terrazas, you may proceed.
Thank you, Your Honor. So this is a screenshot from section E3 of the declaration of the CCRs. And it talks about, because one of the important things here is the common areas. And the common areas are part of what the Francises claim to have purchased from the Homeowners Association, which they're not allowed to do. In fact, under the CCRs, it says that the administration of those shall be in accordance with the provisions of the declarations, the articles of incorporation of the association, and the bylaws of the association. So the only way that common areas can be sold to an individual homeowner is through those different documents. And they don't have that here. In fact, this is E5 of the CCRs. It says every member shall have a right to a non-exclusive easement of enjoyment in and to the common areas. Okay, it goes on and says they also shall have the right and non-exclusive easement for ingress, egress, and support. These are rights that are given to every homeowner who buys into Sierra Crest. These are rights that are the members and cannot be given away simply by a different board that is associated with the Homeowners Association. In fact, it says under the CCRs in section E7J that to amend this, it will be required that 75% of the owners approve that amendment. And again, there is nothing in the CCRs that allow for a transition of any of the common areas to an individual and to take it away from the members. Now we go to the bylaws. Similar things. It describes what in section 4 and 5 in Article 2, what are the common areas and the common open spaces. Two of the things that are very important here. And in Article 4, it specifically states the property rights. And it says each member, this is a property right that is given to them by the bylaws, each member shall be entitled to the use and enjoyment of the common areas as provided in the declaration. So it goes back to the declaration themselves. And the board has specific enumerated powers in these bylaws. Under section 10, related to the common areas, it says that the board, the owners of the board, shall have the power to adopt and publish rules and regulations governing the use of common areas and the personal conduct of the members and their guests. And then in section 11, and this is in Article 6 of the bylaws, it says that the board shall be responsible for the care, upkeep, and surveillance of the project and the common areas. At no point in the bylaws does it ever say that the board has the right to sell any of the common areas. Unfortunately, in violation of the CCRs, in violations of the bylaws, 4.7 acres were sold to the Francises. That's about 205,000 square feet. And it was sold for $11,222. Now, notably, in 2022, right before the sale, the El Paso Central Appraisal District valued just two of the lots that were in that 4.7 acres for $114,769. Not even counting all of the other land. Just those two lots were over $114,000. When the board did this, they did it without seeking an independent appraisal, and they did it without any sort of vote of the members. Instead, this was done at West Star Title, which is related to Mr. Francis, in his bank and was sold for a fraction of what even the CAD value was at the time, not even counting market value. So, Your Honor, we have submitted a number of claims in our verified petition, both against the Francises and against the individual directors. The one that we're talking about here related to this TRO is related to the declaratory judgment to determine who is the rightful owner of this land. And with what the Francises are trying to do tomorrow, that is going to change the character of the land and is going to make it harder and potentially impossible to bring back to what was the original state. And so we're asking the court for a temporary hold on that. So this is what the Francises are trying to do. This is the final replat. They are trying to take all of the area that's in brown, and they are trying to make that one parcel. Now, in addition to the brown colored area, they are also trying to put these two parcels, hopefully you can see my cursor next to the blue line. They're trying to bring land outside of Sierra Crest and effectively annex it into Sierra Crest without a member vote, without any other authorization, because they're trying to make this all into a single parcel. Now, we'll go over, there's some other points of this of why this is going to both change the character and be extremely problematic for the association. But basically what they're doing is they're trying to merge 7 lots of about 15.5 acres into 4 residential lots that vary in size between about 1/3 of an acre to a little over 7 acres. And then convert, and this is really important here too, 4 common open spaces into private open space lots. So changing the character of common open space as it is now into private open space lots. What this will do is it's going to deny access to common open space. It's also going to deny access of a use of a street. And it's also going to deny access to a conservation easement. And then, as I said before, they're going to bring land outside of Sierra Crest into the community. So here's the first problem. So this blue area is the cul-de-sac that leads to the property, and you can see the brown shaded area and then the new land in the yellow at the bottom. Okay, but they're intending to put a gate right here and make this no longer a common open area or common open space, but shut this off so that it is basically only to be used by the Francises. So they're basically taking common open spaces, and by doing this replat, they are going to change it and change the character of it and deny access to the remaining members of Sierra Crest. And we know this also because they have put in the replat that they have submitted that one of the things they're going to do is Part E, is to change the Silent Crest Lane cul-de-sac from a common area to a private gated street. And that is specifically on the replat, in the final replat, which we will provide to the court. It is in this area right here.
Can I ask you a question real quick? Can you go back to the other map with that one? So with that blue road, that's the blue road that will be cut off from other residents for their use as a road in the neighborhood. Along that blue line to adjacent to that road, are there properties of other people?
When you're saying other properties here?
Right, either because that's the proposed private roadway. Are there properties, whether lots or homes, belonging to other people along that roadway?
I do not know for sure the answer, Your Honor, to that. I believe at one time there was, but I don't know if currently there is. But I will tell you, and this is another slide that we have, right here with my cursor, I'm not sure if you can see that or not.
I
and
can.
we've got it boxed in later. That is a conservation area that was given to the Homeowners Association. That will be blocked off. That is something that is to be used by everyone at Sierra Crest. So to somewhat answer your question, whether or not there are other properties along this street, there is a conservation area that was specifically given to the Homeowners Association for use by everyone, and that will be blocked off. And I've got another slide on that as well.
All right, thank you. I think I jumped the gun there a little bit, but thank you.
It's okay, Your Honor. I'm happy to answer any questions that you have. And so the replat violates the CCRs related to common areas because it says every member shall have a right to a non-exclusive easement of enjoyment in and to the common areas. And that street in and of itself is one of those common areas. And so there's violations of the CCRs. There's also violations of the bylaws. In addition, Your Honor, according to the CCRs, and this is Part C, it's C-1, no lot shall be used except for residential purposes, and no structure shall be erected, altered, or placed or permitted to remain on any of the lots other than a single-family dwelling and something that is related to that. Key here, Your Honor, and going back to the map that we had before, is that what we have with this additional land here that is going to, the attempt to replat it, it is not being used in accordance with the CCRs to have a residential dwelling on it. Instead, as Your Honor knows, what is intended here is to put a fence, which is a structure, not a single dwelling, a structure on there that would be not in accordance with the CCRs. And it is important to note that the Francises could put a fence on their current property without this additional space. So, and that would be in accordance with the CCRs because they do have a structure, single family home on that structure, and so they could do it. And so allowing this replat would allow them to violate the CCRs as well in terms of the use of it. The second thing, Your Honor, as we were talking about just before, and this shows where the conservation easement is. That's a conservation easement that was given to the Homeowners Association. And this is the deed of gift, including the conservation easement. And this is from the McAlmans. And again, we have a copy of this that we can submit to the court because this is also a public document that's in the property records as well. And what they say is that for the terms of this conveyance, that it has to remain in its natural, scenic, and open space condition. It says also very specifically that what it is trying to do, and I can give you, let me pull up the easement itself. In the easement itself, Your Honor, just to make sure, can you see this?
Yes, sir.
Okay, it says that the stated purpose of the grantee is to preserve, protect, and maintain the common areas and open spaces in Sierra Crest, a real estate subdivision, which are owned by grantee for the benefit of its members. And it says that it is only giving this grant right here if these recitals are complied with. And so this isn't a situation where they can simply close off this road through this replatting and not provide access to the conservation easement. If they do that, that conservation easement may go away and no longer be of benefit to the members.
Well, I'm going to object to that, Judge. If it may go away, that's not certain at all.
Well,
Thank you.
just following, Your Honor, what the grant of easement says, it says that if it is violated, then it would revert back. So, you know, there's, I'm sure, some legal proceedings that may be there. But it's important to point out to Your Honor, this is an email from Mr. Francis in 2013. So this is about, 13 years ago, where Mr. Francis is talking about this easement, this conservation easement, and says that they fully understand the restrictions to the lot and they intend to honor that document. This replat will violate even what Mr. Francis told to the Homeowners Association about
I'd object
13
to
years
that
ago.
assertion, Judge. That's completely argumentative at that point.
Okay. I'll overrule the objection. So, tell me on that email, this was 10 years before, in what context?
Your Honor, it was the McAlmans were complaining at that point, which again shows what they will do. They were complaining at that point that there was potentially a violation or going to be a violation of this conservation easement, and that they thought that there was going to be something that was built on that lot, on that conservation easement, in violation of what their grant was. And so they're raising this issue to say that that can't happen because the grant was for that limited purpose to keep it as a conservation easement.
But it's
And
talking about a bid. It says, the last sentence says, if we're successful bidders, we will intend to honor the document and will shoulder all legal bills.
I think they were buying another property that was nearby.
Oh, I see. Okay.
Yeah, so they were expand. I think they started with one parcel of that and they expanded into another. And Your Honor, just to be, I want to be candid to the court. I don't know all the details of that. That's what I understand, and so I don't want to misrepresent anything.
Thank you.
So another problem, Your Honor, is replatting will prevent the HOA from maintaining the common areas. The HOA has an obligation under the CCRs to manage and maintain all of the common areas. Okay, that would include the street. That would include the conservation area. By allowing the replat, that will prevent that from occurring. Next, Your Honor, as we talked about before, the replat seeks to merge numerous parcels, including non-Sierra Crest land. This is the non-Sierra Crest land that as soon as it is replatted and it's going to be one parcel, if that happened, that would now be part of Sierra Crest's association, its subdivision. Sierra Crest has not voted to allow that. Sierra Crest doesn't want that to be allowed. Again, I have witnesses here today who are going to be prepared to testify to say that that land is not desirable. That is what that may do is reduce the value of the land that is in Sierra Crest. It also leads out to other areas that Sierra Crest did not intend to be part of its property. Why is this such a problem? Because if we allow something like this to happen, then it would allow other homeowners at Sierra Crest to effectively replat other lands that's outside of Sierra Crest and bring them into the subdivision.
Okay, that is something to this TRO, Judge. That speculation's irrelevant, Judge.
Well, I understand. Well, you have to understand the nature of what we're doing here, Mr. Morales. This is a TRO. While we do give you notice, and I will certainly give you an opportunity to respond to the burden that has to be demonstrated for me to even grant it. It doesn't. This isn't a probative hearing. This isn't one that is based on what a fact finder would find in a jury. So I understand your objections and you're trying to limit the information I receive, but in a TRO, it's much broader than what you would typically see in a trial or those things. So I'll give you your opportunity to respond to the burden that the petitioners will have to have me sign a TRO. But it's all pretty speculative. I need to decide right now whether there's a probability of their success, and that in and of itself is speculative. So the conclusions he draws from the evidence and facts that he has to proffer to the court, um, don't get interrupted by admissibility, your typical admissibility objections. I understand the speculative nature. I can identify the difference or not, and if I think it's too speculative, then it's something I will disregard, and it'll decrease their chances of me granting the TRO. If something seems to be supported by what I'm being told, then I'll rule otherwise.
I understand,
But
Judge.
all right,
I
thank
understand,
you.
Judge.
Mr. Terrazas?
Thank you, Your Honor. So this is some of the impact of annexing the new land. This is related to the application for the fence, and what the Francises are looking to do is expand this fence to the edge of that property out to another street, which, by the way, does not connect to the Sierra Crest land. That's what these red arrows are, is the attempt to move a fence outside of Sierra Crest property, which would again bring it into and effectively annex the land. Also, Your Honor, by merging the parcels would violate the CCRs, because it allows an owner, the CCRs allow an owner to take two lots and combine them for the purpose of constructing one single family dwelling. The CCRs do not allow the combination of multiple lots to be combined where you do not put a single family dwelling on top of them. And this matters for a lot of reasons, including for the amount of assessments that go into the HOA. Because if you have a number of parcels and you combine them all into a single parcel, then technically under the CCRs and bylaws, the entity or the person, the owner, would only have to pay a single assessment as opposed to the multiple assessments for that land of what the subdivision had laid out at the beginning.
But tell me that part again, as far as how the first part. You're saying that the problem is that you can't buy two lands for the purpose of constructing one single family dwelling. Is that what you said, or
No,
understood?
I'm sorry, Your Honor. No, you can do two lands for purpose of constructing a single family dwelling.
Right.
What you cannot do, and let me go back to right here as an example. So in this area, in this box, these two parcels were lots that were intended to be sold, and they are surveyed to be sold. There is no structure that is supposed to go on there. These other portions are supposed to be common open spaces. Okay? And all of these were sold to the Francises, we believe improperly. But they're not intending to construct any sort of single family dwelling on those structures. And that would violate the CCRs and the intent of the CCRs in order to leave the lots so that they are sold and so that they are only combined, only two lots are combined if you are building a single family dwelling on top of it. Now, Your Honor, in terms of the replatting, more than 30 lots have filed oppositions to this replat with the city. The city has said that this is a ministerial type act, such that they have recommended approval of the replat. unless the court intervenes here. And therefore, this is something that, and we've got as well the agenda for the City Plan Commission for tomorrow, where this is set at 1:30 tomorrow to be approved in terms of the replat. So this is imminent. In addition, Your Honor, replatting will change the character of the land and neighborhood. We have different lots right now that were common open spaces, some of which are now private open spaces, and one of which, as soon as they gate that street, will change from a common open space to a private open space without access to the conservation easement and the other portions of the common open spaces. In addition, it's going to add the unapproved land into Sierra Crest, which is irreparable harm here. This is not something that can simply be changed, and it cannot be, money will not resolve the discrepancies here or compensate the homeowners association appropriately. So, Your Honor, there's an inadequate legal remedy here where we got 7 parcels merging together and the common areas and conservation easement not being accessible, and then residents being denied use of the roadway. And again, I have, for example, Ruth Ojeda here today, who will talk about how she regularly uses that street as a turnaround because it's got a cul-de-sac in there, and that won't be available anymore. It's those type of things that will change the character of and will be irreparable harm for the owners of the homeowner association. So, Your Honor, in conclusion, and I'd like to go through the exhibits we'd like to enter as well, but for the status quo, the last peaceable moment was prior to the sale of these properties. And the replat seeks to modify those parcels that are subject to this litigation. The Francises are actively pursuing a replat that will happen tomorrow if the court does not intervene. And once it's recorded, it's going to change the character of the parcels. It's not easy to undo that. Then I know the argument on the other side is that they can just undo it, but that's actually not the case, particularly for the annexed land. Because you can't, even if you undo it, it's still, once it is platted into the subdivision, it stays as part of the subdivision. All we are seeking today, Your Honor, is a 14-day pause on what the Francises can do to pursue their replatting. We will ask for a temporary injunction hearing. We are prepared to provide a bond. Our proposal is that it's a $100 bond because there is going to be no prejudice to the Francises to wait. This is something that's been going on for several months. This hearing has been delayed by the Francises several times, and so a brief delay further is not going to provide any harm. But we can set a temporary injunction hearing for 2 weeks from now. The parties can work out if they need to delay that further, and then move forward with this. And so, Your Honor, I have several exhibits. Let me pull those up. So, Your Honor, the first exhibit that I have is the CCRs, the declaration and CCRs themselves, which again are entered into the property records of this court. And Your Honor, I don't know if it's easiest to do one by one or just to provide all of them at a time. What would you prefer?
If you could, let me see. Are they already numbered?
I don't have them numbered, but Ms. Arambula will be numbering them as we go. The CCRs would be Exhibit 1. The bylaws, which are the second one, is Exhibit 2. And these are the amended bylaws of the Sierra Crest Homeowner Association dated 2021. And again, I have witnesses that are able to verify these are true and correct copies of these. The next exhibit is the preliminary the next exhibit is the seller statement for March 2023, which was the actual sale of the spaces themselves, which was right after the last peaceable moment here. That's exhibit 3. Exhibit 4 is the preliminary plat that was submitted by the Francises. Exhibit 5 is the final plat that was submitted by the Francises. Exhibit 6 is the City of El Paso agenda for the City Plan Commission, which is a public document that's been released. Exhibit 7 is the deed of gift, including a conservation easement, which again is in the public records. Exhibit 9 is a portion of the replat, which is an attachment to the replat application. It's dated July 16th, 2026. And then the last exhibit, which would be, I believe, exhibit 8, is the email from Mr. Francis. I believe those are all of the exhibits, other than we have in our application, we've got the declaration of Armando A. Barron in support of the temporary restraining order, and that verifies some of the documents as well.
All right, thank you. So those will be made part of this record.
Judge, just for purposes of the record, I'm not waiving my objection to those, Your Honor.
I understand. Thank you. We don't even have to be on the record. I just want to memorialize this conversation.
Yes, Your Honor.
But they will be made part of the record. Mr. Morales, I'll give you the opportunity to challenge the whether the burden has been met for a TRO.
Your Honor, well, first of all, as the court's well aware, this is basically a three-pronged issue. First, they have to prove a cause of action against the Francises, as I'll refer to them as Francis collectively, just for expediency. But that's the first prong. The second prong, obviously, is they have to have a probable right to the relief sought. They have to have, third, a probable, imminent, and irreparable injury with no adequate remedy at law. And this is, in fact, their weakest element at this point, Judge. I think that they lose on either 2 or 3, but if we look first at the irreparable injury, basically, Judge, a replat is a recorded map revision. It's a paper act. It doesn't remove anything. It doesn't remove any soil, earth. It doesn't build anything. It doesn't foreclose any relief. It's reversible by a further replat or any judgment should the plaintiff prevail on the larger lawsuit. Judge, things will go back to the status quo ante if the court rules ultimately in favor of the plaintiffs. Now, if they prevail on the title, the deed is voided and the replat falls with it. A harm a final judgment can completely undo is not by definition irreparable. It is repairable. Their own pleadings provide an adequate legal remedy, Judge. They seek $1 million and recovery of the land itself to quiet title, declaratory title. That a party made whole by money and land, again, has an adequate remedy at law. There is an
say that part again, the first part about the $1 million.
The first part, Judge, is that their own pleading provides an adequate remedy. They seek $1 million and recovery of the land itself. A party made whole by money and land has an adequate remedy at law, Judge. So every pleaded harm, the lost assessments, the tax, the reduced tax valuations, the dues, shortfalls, all quantifiable in dollars, Judge. That's the definition of an adequate remedy, not an irreparable injury. They also have a lis pendus available to protect their claimed interest without an injunction. And the court knows what that means. So there is no irreparable injury, Judge. There's various adequate remedies at law available to the plaintiffs, short of a temporary injunction or a temporary restraining order than that. The replat changes nothing on the ground, Judge. There's nothing that cannot be undone by the stroke of a further replat or by the judgment should they prevail. And by their own pleading, they seek money and the land. That's an adequate remedy at law. There's nothing being changed here. Nothing, you're not going to hear anything today about anything being built except perhaps this fence that really lies at the heart of all of this and was the initial lawsuit filed years ago, Judge, in this instance that I know you're familiar with. This issue with the fence and the protection of the Francises and all these types of things, and the protection of the entire association, the whole neighborhood, Judge. But nevertheless, there is an adequate remedy at law. And there's no probable right to enjoin the conduct that the board itself directed. The relief they seek to restrain the Francises from is replatting, but the board is the source of that replat obligation. It goes back to the original contract that the Francises signed to obtain the property. Now, Mr. Terrazas claims that is an illegal contract, or it should be voided, or wasn't the authority of the board to enter into that type of agreement. But nevertheless, the obligation exists. The board formed a committee. They studied the security proposal, approved the sale of 4.7 acres for $11,222, which was the central appraisal district value at the time, Judge, on the express understanding in the board's own minutes that the Francises would replat as part of the deal and accept the costs and the expenses of doing that. They cannot show a probable right to enjoin the Francises from doing exactly what the board required. Their own conduct materially weakens the probable right showing, Judge. So we go now to what's the balance of equities, the status quo. The Francises are the recorded owner continuously of this property since March 3rd of 2023, 3+ years undisturbed, Judge. The two buildable lots were never offered for sale in the preceding half century. The association's own improvements, planters, plantings, part of the subdivision gate entry, they sit on that ground. That is the settled character. An order halting that replat disturbs the status quo. It doesn't preserve it. Mr. Francis has spent now well over $250,000, probably more. He's going to testify to more, I believe, acquiring and expending on this replat, acquiring the joining lands from private third parties, a part of which he is gifting to the association, Judge, through this very replat. The replat adds common area. Mr. Francis will testify to that, Judge. It doesn't strip any land. It doesn't take anything away. The real imminent harm runs to the Francises, Judge. The August 2025 intrusion, masked man, pre-dawn, bypassed security, passed the unfinished fence, looked indoors, windows, entered the rear patio with Mrs. Francis present. Now, they fled when they were confronted, but they were captured on cameras and reported to the guardhouse and to neighbors. And the board was aware, and no one contacted the Francises. The sale and the fence, the measure adopted to address this exact danger is a harm to the Francises, Judge. It leaves the danger unabated, not just to them, but the entire homeowners association. The fence proposed was supposed to protect the entire area, Judge. That was the intent, to protect the entire association from these types of intrusions, because there's no fence there, Judge. You know the criminal law as well. Without some notice of entry onto or trespass onto a property, there is no trespass. And there's no physical barrier. There are no signs. There's nothing leading up to these homes where association members live. Something has to be done. Now, they argue, Judge, that the replat changes the character of the land. Now, the recorded map revision is not a physical or permanent change, Judge. Again, nothing is proposing to be built. There's no soil being removed, and the replat adds the common area. It adds to the association and their value, and to the use and enjoyment of the other members of the association. That's the definition of common area. So if they claim urgency or imminence, the Francises have owned this property since 2023, Judge, and the replat has been in process for over a year now at the board's direction. Nothing new or imminent. The emergency is manufactured. Their harm is, if any, is slow and it's monetary and something that can be reversed. Maybe it'll take a little effort, but it can be reversed. There is nothing that is permanently changed. Now, what we ask, Judge, is that the court deny this application in its entirety, and if any relief ensues, well, we condition this on Rule 684 for some kind of bond and narrow it to preserve but not to alter the status quo, Judge. And again, we appear under the auspice that we want to preserve all of our service of process objections, answer rights, and things of that nature, Judge. I know the court's well aware of that. So I just want to, again, note that for the court's information, the nature of our appearance. But I think this should fail on many points, Judge. There's just no reason for this right now, Judge. There's no reason to stop this replat that would come at a great expense to Mr. Francis and Mrs. Francis, and that has been planned since the outset, since the purchase of this property. This was always the intent. There's nothing new here. And this imminence is manufactured by the plaintiffs in this case, Judge. They've waited up until this time. They blame Mr. Francis for delays or whatnot. I'm not aware of those delays, but this petition was only filed recently, and this request has only come recently. So that's where we are, Judge.
Okay, let me clarify something. Mr. Terrazas, are your clients seeking to recoup the land from the Francises and have it restored to the public as common areas without any future sale? Or is the dispute the selling price, that it was done, and the manner in which it was done? It was done outside the procedure required by the bylaws, and the amount paid was way less than the actual value of the property, so that Sierra misses out on those proceeds that should have been. It was like almost a fraud of a sale, simply because they underpaid what the true value was.
So, Your Honor, it's actually a little bit of both, and let me explain. So we are seeking to return the common open spaces to common open spaces. There was part of that 4.7 acres that was purchased that were common open spaces that should not have been sold at all. But there is also 2 lots that are buildable lots. We are not seeking necessarily to return those to the association. We believe it was improper for those to have been sold the way that they were, but they were sold. Those are the ones that we showed that even under the El Paso appraisal district, that they were $114,000 just for those 2 lots. So the answer to your question is both, in terms of there are some that we are seeking injunctive relief on just simply to return it back to the association, but then there's others that we are seeking to return it back to the association, but if it can't be returned back to the association, the 2 buildable lots, then it should have been at market value for those.
And you're the one who said that there have been delays, or you first brought it up. I'm not clear on what those delays were or the why, but I think Mr. Morales makes a point about the imminent harm. The property was sold 3 years ago. We've had ongoing disputes about all sorts of things around these neighbors, and but what have been the delays?
Well, so Your Honor, I do want to respectfully throw it back on my friend on the other side a little bit, that what Mr. Morales was saying is that according to the board at the time, which we have claims against the board members because we believe they breached their fiduciary duties in what they did. He is claiming that that board back in 2023 said that the Francises needed to replat the land. They didn't attempt to do that for over 2 years. So when we talk about delays here, the replat and coming to a decision by the city of El Paso to actually replat it, it wasn't until very recently. And it was delayed several times. I don't know the exact reason why that those were delayed. But we tried to pursue this TRO and understand the local rules. We were trying to make sure that we were not delaying at all. And so we tried to do this over a week ago. And it was moved to here with the hearing tomorrow. This wasn't a situation where we had something that the replatting decision was going to be made in the near term until just recently. And so that is the source of the delays, both from the delay to even seek replat, and then finally when that replat became something that was likely to happen, that's when we filed our TRO and sought to be before the court.
Mr. Morales, do you know when Mr. and Mrs. Francis made their application for the plat, for the replatting?
I believe that was well over a year ago, Judge. I could ask Mr. Francis on and take testimony on that, Judge. I don't have an
Okay.
immediate answer for you.
I don't really want to take testimony. The only reason I'm asking is this whole, how imminent is this problem? And we bring this TRO all of a sudden, either we bring it because it's a strategic move but we've known about this since 2023. And while maybe some people were unhappy about the fencing, people were unhappy about how the sale occurred, concerned about losing the conservation easement, all those things, but it took 3 years. Or all of a sudden, Mr. Francis decides to apply, a month ago, and so we have to hustle to stop it. So that's the reason why I'm asking.
And that is not the case, Judge. That is not the case. This has been a plan that has been ongoing for some time now, well over a year. Like I said, there were any number of actions taken by the Francises to initiate the replatting. They had to have engineers in, they had to have surveys done, they had to have all these things done. And these have all been activities that have been open and notorious, things that have been going on with the full knowledge of the members of the association, as well as the neighbors and everyone else that's involved. This is not something that came up just last week. And the planning, the zoning board, as Mr. Terrazas referred to, that happened some time ago. I don't have the date immediately in front of me, Judge, but it happened a while back. This is just the final date approving of it, but the hearing was some time ago. This was months ago.
Okay. So, Your Honor, I've got in front of me right now the application for the replat. It was February of 2026. Notice was not given until March is the first one, but then it was re-noticed on, I believe, June 29th was the next one. And of course, there was a receiver in place during that first notice that the Homeowners Association couldn't do anything at that time, with the second notice of June 29th. And then there was the application process and notice and the resetting of these hearings. This is not something that's been going on for years in any way. And so, and again, I can provide to the court the replat application in February. So respectfully, it was not over a year ago in any way, shape, or form. And the Homeowner Association did not hear about this until the first time was actually within this last month. But
again, Judge, my point is that this was initially negotiated with the board. The replat was part of the covenant of the purchase of the property initially, when the Francises first approached the board, first purchased the property. The replat was well known to everyone. Now, they took steps over the years to get things situated so that they could formally apply to the city board in order to be able to complete the process, the application, and the rest of those matters. So this has been going on for some time. I don't disagree with Mr. Terrazas. I can't countermand an actual city document. I believe that's accurate. However, I think it's inaccurate to suggest that this is something that just came up 4 months ago. This has been this activity that's been ongoing for some time, and the litigation that's been ongoing, as the court knows, since what is it now, 2024? So this has been activity that's been ongoing for quite some time.
Okay. Woody, I need the injunction date, please. So, and it's no, we're not gonna go past 2 weeks. We have to do it within 2 weeks. Well, maybe, I don't know. So it does pivot around a couple of things on really pointed out by Mr. Morales. Is there an adequate remedy of law besides the injunctive relief at this point? And whether there is imminent harm to Sierra. This is a administrative procedural matter that's happening with the city on the replatting and whether well, I do think that because the association was in receivership, their hands were rather tied by me on what could be done. I think the first point of order was to restore proper leadership to that organization before before anything else happened. And I know this fence dispute came up, and we kind of touched on this property sale, but didn't get into the weeds of it as we have today. The One of the questions I have is like, well, do we want to allow the process with the city to go forward? And then I can enjoin part of the intentions. The city can replat, but doesn't mean that I would allow the Mr. and Mrs. Francis to act on it, to either redesign the road or any of those things. Or and then if the Sierra ends up prevailing, then we have to undo it. Or do we just flesh it out now and postpone it? Do they meet monthly, the city planning people?
I don't know how often they meet, Judge, but I think there is some effort that needs to be made to be able to get back onto the calendar, and that would
Yeah.
leave my clients at some significant financial loss.
Why is that?
Because they've had to go through this expense. I don't know if they can go back next month, Judge.
Or
I don't
next
know.
month or in 3 months or however long it takes us to
Yeah, I
adjudicate
don't
the
have an
merit.
answer. I don't have an answer to that,
Yeah.
Judge. I don't know.
I mean, I think all the expense has been done already with just preparation of that application, and the purchase of the property, but
Yeah, as I suggested
uh,
to you, Judge, I think the replanting's already been approved. This is just kind of the formalization, is what's happening tomorrow, is the way I understand it.
okay.
And Your Honor, to be clear here, the replatting does not go through unless it is voted on tomorrow. There's preparation that has gone on. We agree with that, but there's a requirement for this to be approved in order to go forward. And the court, if it enters a TRO, will delay that. I believe that the last hearing that was supposed to happen for this replat was about 2 weeks ago, and the Francises delayed it, and again, I don't know why. So this isn't something where they only meet once a quarter or something like that. This is something that can get back on the calendar if need be after we have a temporary injunction hearing and the court has heard evidence and can decide.
And it wouldn't start it all over again. It would
That's right.
start at that point where it's either a yes or a no.
That's right, Your Honor. I don't believe that there's any additional cost or anything else. This is simply something that they will have the hearing if the court allows it to go forward after a temporary injunction hearing.
So I am going to grant the temporary restraining order, and that will delay this last point in the planning procedure. We will have a temporary injunction hearing, an evidentiary temporary injunction hearing on August 7th at 1:30 p.m. And I'm reserving the entire afternoon for this proceeding. And at that time, we'll hear testimony and see if the injunction will proceed. But thereafter, then we will no, in person, Woody. And then thereafter, we'll set it on the merits. The trial.
And Your Honor, we have submitted a proposed TRO that's been provided to your chambers. And I don't know, because we didn't know Mr. Morales was joining the fray, if he has seen it. But we do need to respectfully have it signed today so that we can present it to the city of El Paso.
What time was that again, Judge? On the 7th?
On the 7th at 1:30.
1:30.
The let me see, Uri, where's that order? Do you have it on email, please? Mr. Barone? Okay, he just sent it. Uri, when did you send it? Okay, I don't know why, but I'm not getting it. Oh, there it is. Mr. Morales, I'm going to review this order. I do see very quickly that I need to maybe edit it, but it is going to be limited to continuing to advance the application to replat. You know, any efforts to do any of that, any recording of any change in the plat in that subdivision, and no conveyance of the property, creating new parcels. I mean, and that's it. It's pretty much a 2-page thing. It was sent to Judge Dominguez instead of the 41st, instead of here. So I just need to do some quick edits with regard to that. And I'm gonna get that signed. What I'm gonna do is I'm gonna e-file it, but I'm gonna copy you, Mr. Terrazas, Mr. Morales, Mr. Greer. Do you want a copy, or do you wait till the e-file? Actually, you're only here because the other one has a status, right?
Correct, Your Honor.
Yeah. Okay, so it's just gonna be you two, that'll make it quicker for me to send it out to you.
Just so we're clear, this would not prevent my clients from trying to reschedule this with the board, the replat, in other words. I understand the court's order for the temporary injunction. However,
Yes, it will.
if they were to reschedule for next month, for example, I mean, pending the TRO, sometime after that.
Pending the temporary, if I grant the temporary injunction, it just gets delayed again. So yeah, it does. I mean, I don't see why they would want to do that, but
Just to get back on the calendar, Judge, if nothing else.
that's assuming that it won't get rescheduled again, because or even allowed at a later point. I would not do that.
That's sort of the problem, Judge, is that right now I don't know if they can even reschedule it at this point, or if it's just gonna fall through.
Well, by virtue
And it
of my
makes the entire
order,
issue moot.
then they cannot. They cannot do that at this point.
Understood, Judge.
Okay.
And Your Honor, in terms of the exhibits that you're including as part of the record, should we email those to Mr. Barone?
Yeah, and then he'll get it to our court reporter.
Thank you, Your Honor. Will do.
All right, so let me get this done. And is there anything further, Mr. Terrazas or Ms. Arambula?
Judge,
No, Your Honor.
while we're on, if Mr. Terrazas could do me the courtesy of sending me a copy of those exhibits, I don't know that I have all of them.
Absolutely. When we do to Mr. Barone, we will make sure that we get it to you.
All right,
I
thank you, Mr.
think we
Terrazas.
have your email, but we'll find it if we don't.
Very good.
All right, thank you very much. Is there anything further, Mr. Terrazas?
No, Your Honor. Thank you.
Is there anything further, Mr. Morales?
Not at this point, Judge.
All right, thank you all for your time. Then we will be having our hearing on August 7th at 1:30 p.m. It'll be in person. It'll definitely make it easier on the reporter if it's in person. I believe all witnesses are local. So I don't know where you are, Mr. Terrazas, but welcome to El Paso.
I will be there, Your Honor. I've got several cases there, so we're good.
Thank you. Then at this time, we're adjourned.
Thank you, Your Honor.